My name's Matt Gingell and I'm a partner at Gannons, specialising in employment law. And I've particular experience with dealing with executives and executive strategy for leaving businesses. There can be a number of different scenarios when employees are considering leaving the business. For example, there could be a redundancy or restructuring situation. Particularly in the financial sector, executives are often offered enhanced redundancy terms on condition that they sign a settlement agreement. A settlement agreement effectively means that the executive waives their rights to bring certain claims, and in consideration for that, the executive will receive an enhanced redundancy payment, which is usually considerably above the statutory redundancy payment. There may be limited amount of negotiation which is possible in these circumstances, particularly where the executive is receiving considerably more than the legal requirement that the business has to offer. But there are a number of matters that need to be considered, and I've got considerable experience of advising executives on the process and what needs to be looked out for. There is, for instance, the issue of deferred bonus awards. Particularly employees working in banks and other financial institutions may well have had bonuses awarded to them, and we need to consider whether those deferred awards will continue to vest or be accelerated. Usually for an employee who is being made redundant, they would have good leaver status, and therefore any awards that had been awarded previously would continue to vest on the usual vesting dates. They may be shares, they may be options, or they might be accelerated at the time of the termination date. But that's certainly something to consider and to check. Also, there may be issue of restrictive covenants. These are covenants which means that, for example, employees may be restricted from soliciting clients, they may be restricted from soliciting employees of the business for a certain time when they leave. There may be other restrictions that may mean, for example, that the executive can't go and work for a competitor for a period of time. These restrictions would usually continue to take effect even if an executive is being made redundant. It may be possible in certain cases to ask the employer if certain restrictions could be waived, and this would be something that would need to be taken up at the time. Another point is references, and references usually tend to be standard now, particularly in the financial industry. References may just include dates of employment, job title, but again it's worth checking that these references are correct, and they may well be attached to the settlement agreement so that the executive knows exactly what's going to be said when they leave. Tax is another consideration. For enhanced redundancy payments, usually the first £30,000 of the payment can be tax-free. The settlement agreement would normally refer to this, but this is another point to check.